Good morning, everyone. Hope everyone slept well, is all rested and ready to go for an interesting day. We're a little bit behind, so if I can encourage people as quickly as possible to get in your seats. I'm Steve Smith, and it's an honor for me to be on this panel today. I think Ilya's paper is very interesting, and it has something for probably everybody. I think historians of different periods, theorists, and I know there'll be plenty of questions about it, so I don't think I'll waste any more time. I'll just turn the time over to Ilya for his 10-minute presentation. Then we're pleased to have Michael McConnell here to give a response, and I'll be keeping track of the questions.
So I'd like to start by thanking the organizers for arranging this exciting conference, and Michael for generously agreeing to comment on the paper, and all of you for waking up early to listen to a talk about public use, not normally what I would consider necessarily a fun activity early on a Saturday morning, but hopefully we will provide as much entertainment as we reasonably can with a subject like public use. The chapter that I'm presenting today is part of a larger project about the Kilo case and about public use, where I address both legal and policy issues related to it. As most of you probably know, Kilo versus City of New London is a 2005 decision by the Supreme Court, where the court ruled that takings that transfer property from one private party to another in the hopes that it would produce more economic development, that those are permissible under the public use clause of the Fifth Amendment, which is generally interpreted as only allowing condemnations that are for a public use. The court in this case, and in some previous cases such as Berman versus Parker, interpreted public use to mean any kind of conceivable public benefit. And this, of course, is what I in the paper call the broad definition of public use. Almost throughout American history, the broad definition has been in contestation with the narrow definition, which is that a public use must be either ownership of the condemned property by the government or ownership by some private entity, such as a public utility, that has a legal obligation to serve the general public. In the book as a whole, I argue against the result in Kilo on a variety of grounds, including living constitution grounds. If any of you are organizing a conference on the living constitution, I'd be happy to present my chapter 3 of the book, which explains why Kilo is wrong under at least many widely accepted theories of living constitution, maybe not all possible living constitution theories, but many of them. However, in this chapter, I discuss the originalist case against Kilo. The chapter also is a sort of history of 200 years of public use doctrine, including some material which isn't necessarily relevant to the original meaning. Obviously, I recognize that this covers a lot of ground, and so I'm very much open to the possibility that maybe there's some stuff I missed or underemphasized, or some evidence that I should consider more differently than I have. Perhaps we can discuss that during the question period. In the chapter, I look at the original understanding of public use in two relevant periods. One is 1791, when the Bill of Rights was first enacted. The other is 1868, when the 14th Amendment was adopted, and therefore the Bill of Rights first became applicable to the states. And in both cases, I suggest that the narrow definition of public use has greater support in the original materials than the broad one. So turning first to 1791, at that time there was very little discussion of not only of public use, but even of the Takings Clause more generally. The Takings Clause appears to be the personal brainchild of James Madison rather than the result of any kind of widespread belief that it was necessary. As Will Bod showed an article in 2013, most people at the time believed that the federal government didn't have the power to use eminent domain in the states, which may be one reason why there wasn't strong pressure for a takings clause. However, such discussion as there was strongly suggests that the dominant belief at the time was that takings that take from A to B, as famously described in the Supreme Court decision of Calder versus Bull, are in fact contrary to the underlying principles of the Constitution. They violate the natural rights theory of property rights that underpins the assumptions behind the Takings Clause, and you see these assumptions spelled out in two well-known 1790s decisions by Supreme Court justices, one Calder, the other Van Horn's Lessee. Some people have argued that practice at the time supported the idea of a broad interpretation of public use, and they in particular point to takings for mills and also takings for private roads. I discuss the nature of those kind of takings, and I suggest that in virtually all the Mill Act statutes that existed during this period were in fact that allowed takings for only the kind of mills that actually were public utilities. They were required to serve all comers. They were under specific types of regulations and the like. As for private roads, there's greater ambiguity there. However, when courts actually heard cases under these private road statutes, what they did is they essentially said, well, we interpret these laws that the roads aren't actually private, but that the general public has a legal right to use them. So they didn't actually uphold takings where it was truly for a private road, i.e. one where I own it and the only people who get to use it are whoever I let in there. So turning now to 1868, where there's a lot more evidence, I guess the first question we would ask is, why should we even look at 1868, given obviously that the Bill of Rights was enacted in 1791? I think the reason why is that here I'm following scholars like Akil Amar and also Mike Rappaport, our conference organizer, who have argued that when we consider how the Bill of Rights applies to the states, we should consider its meaning at the time that it actually became applicable against the states, namely in 1868. This is the subject or the thesis of Akil Amar's famous book, The Bill of Rights, and obviously a number of other scholars have taken similar positions. So if you take this view, as many scholars do, then 1868 is relevant. And by 1868, and the period immediately thereafter, we have a lot more evidence because by this point, numerous state Supreme Courts had already issued decisions interpreting the public use clauses of their state constitutions, which in almost every case during this period had virtually the same wording as the federal public use clause, and there was clear disagreement here. However, a strong majority of the states, 16 of 25 by the 1870s, had endorsed the narrow definition of public use. If you push things out beyond 1877 to the turn of the 20th century, you get an even larger majority of states supporting a narrow definition. In addition, there was by this point a good deal of professional discussion by treatise writers and the like of the meaning of public use, and a dominant view among them was also that the narrow view is correct. This was the view taken by Thomas Cooley in his famous treatise written in 1868. Cooley was the leading 19th century authority on state constitutional law. It was also the view taken by John Lewis in his famous 1888 treatise, Eminent Domain, the first American treatise specifically devoted to eminent domain law, and also other more obscure experts that I cite. Moreover, a similar view was taken in the few rare discussions of this by Supreme Court justices in the antebellum era, such as Justice Levi Woodbury in the West River Bridge case. In the chapter, I also discuss the state's decisions in the Mill Act cases, which are often cited as support for a broad definition of public use, and I argue actually that the majority of these Mill Act decisions at the state level actually support the narrow definition, though certainly not all of them. Finally, I'd like to talk briefly about how this cashes out under different theories of originalism, because we all know that there is disagreement between originalists themselves on what evidence they're actually looking for. And the dominant view today is original meaning originalism, but original meaning originalists disagree among themselves as to whose understanding of the original meaning is relevant. Some believe that what matters is the understanding of the general public or of an ordinary reasonable speaker of English at the time who doesn't necessarily have specialized expertise. Others argue that what matters is the understanding of either actual experts or more typically some sort of hypothetical reasonable person to whom an extensive knowledge of law is imputed. In my view, the narrow definition has stronger support under either of these interpretations. If you just take the popular understanding of people who don't have specific knowledge or training in the the law, it is very likely that they would gravitate towards a literal meaning of public use as opposed to a metaphorical one. In most ordinary contexts, when we use the word use, we mean some kind of literal use. Only some specific context that points to a metaphorical use would be necessary to support that. Moreover, the literal approach is more in accordance here with the strong emphasis on property rights that existed in 18th and 19th century American political culture. When you turn to knowledgeable observers, those knowledgeable observers, either actual or hypothetical, would have known that the majority of state Supreme Courts endorsed the narrow definition, and that was also the view of the majority of treatise writers and other experts. Moreover, they would know about the canon against redundancy, that the Constitution should be interpreted in such a way as to not render words superfluous, and the broad definition of public use does in fact render public use superfluous because it suggests virtually any taking could be for a public use, as was recognized by people like Cooley and also the Ohio Supreme Court. They recognize that any taking that gives property to anybody can potentially create a benefit for that individual, and benefits to an individual, at least to some slight degree, are benefits to community as well. Therefore, you might as well not have the words public use in the Constitution if you adopt that position, and that's not just my conjecture, but it was recognized by people at the time, and that violates the principle against redundancy. I think this is something actually that might weigh not just with experts, but potentially could weigh with ordinary people to the extent that they might think that words in a legal code or in a legal document are ones that shouldn't be treated as if redundant. I think ultimately, also in the book, I discuss original intent and why it would come out, I think, the same way under original intent. I don't have time to go into that right now, but I'm happy to talk about that if you're interested. Ultimately, it is not my view that there's some one particular piece of killer evidence or smoking gun evidence that definitively resolves this issue. I think there is some evidence to support both sides of the question, but I also think that the evidence supporting the narrow view is overall significantly stronger than the evidence on the other side. And with that, I very much look forward to Michael's comments and to your questions. Thank you so much.